yesterday by this court. May I hand that up? Court has convicted murderer awaiting sentence, and we acknowledge that the accused has a right to apply for bail pending sentence and or pending an application to the Constitutional Court.
Yes, the accused may be seated in the meantime as we are busy with the proceedings. Yes, Mr.
Thank you, my Lord. My Lord, for purposes of this application, which is an application in terms of the provisions of Section 6011B of the Criminal Procedure Act, that is what we refer to as the so-called Schedule 5 offence, which this conviction falls into. We have prepared an affidavit. May I ask leave, and I will then deal with this affidavit, to make available to you the signed affidavit. It's signed by the accused, and I would ask the court to accept it as A in these proceedings.
So are you going to call any witnesses, or the application is just based on the affidavit?
It's going to be based on the affidavit, and if I may say, we made the affidavit also available to the state yesterday.
Okay. And the state? Are you going to call any witnesses? Are you opposing the application for bail?
No, it won't be unopposed. We'll make submissions from here,
right,
as far as the application is concerned.
Thank you.
Subject to your direction, I will only refer to the main parts to explain the bail affidavit without having to read it into the record.
Yes.
Because it is, the state has seen it and it is before the court then. The structure is to deal with the personal circumstances and to accept that this is a Schedule 5 offence for bail purposes, and that there is then an onus on the accused to satisfy the court that the interest of justice permit his release. The history of the bail matter, my Lord, is dealt with at page 3, and you would see from that right from the inception of this case, the accused was released on bail. He was first released on the basis of premeditated murder. Bail was granted in the Magistrates Court, Pretoria. There was an appeal, but to the High Court, this High Court, but only in relation to certain conditions. The appeal was heard by His Lordship, Mr. Justice Bum, that was successful in respect of some of the conditions, and the conditions were amended, which are not really relevant for present purposes. Thereafter, the accused stood trial. He abided by all the conditions all the time. And, of course, when he was convicted of culpable homicide, the bail lapsed. There was a formal application for the extension of his bail, which was granted. And when he was sentenced, the bail lapsed. And at that point in time, the accused chose to commence with the serving of his sentence without, again, asking for bail pending any further proceedings. The next step, my Lord, was then an appeal in terms of the provisions of Section 319 of the Criminal Procedure Act to the Supreme Court of Appeal on 3 questions of law. The first 2 questions of law were found to be successful, and as a consequence of that, the Supreme Court of Appeal set aside the conviction on culpable homicide, and accordingly also set aside the present sentence, to which I will revert now, and convicted the accused of murder in the sense that he acted with the criminal intention of relevant to dolus eventualis. Before and up to that time, the accused served a sentence that was imposed by the trial court. That was a sentence of 5-year imprisonment with due regard to the provisions of Section 2761I of the Criminal Procedure Act. That sentence provides that an accused would generally serve 1/6 of his sentence, and then the remaining part of his sentence in terms of conditions under correctional supervision. The accused was released after 12 months, and he commenced his sentence in terms of the conditions of correctional supervision at the end of October 2015. For the purposes of the present bail application, and you will see this from the affidavit, the accused has offered to proceed with the house arrest, but on stricter conditions. Previously, in terms of the correctional supervision conditions, he was allowed to leave the house at 230 Lawley Street, Waterkloof, Pretoria, between the hours 7 o'clock and 12 o'clock. He has agreed, and agreed so with the state as well, that he would abandon that right that he had in terms of the previous sentence and the previous conditions, and that he would accept that he should remain in house arrest at 230 Lawley Street, Waterkloof. Should he, for whatever reason, need to leave the premises, he would do so with the permission of either the investigating officer, Major Mike van Aert, or Advocate Johnson here. That's also agreed, subject, of course, to your sanctioning, my Lord. He also agreed, subject to your sanctioning, that he would submit himself to electronic monitoring to be monitored in terms of Section 62F of the Criminal Procedure Act by Mr. Stalls, a probation officer in the Department of Correctional Services.
Mr. Roux, this condition in respect of the house arrest, that he could leave between 7 o'clock in the morning and 12 midday. Why is it necessary to change it? What prompted that?
The state insisted on that. We weren't too keen, but in order to get to an unopposed bail, that's for that reason.
Okay, yes, you may proceed.
It was solely for that reason. There was no other reason, just to get
Thank you.
some agreement. It is also that the accused would subject, and all subject, of course, to your direction, my Lord, that bail amounts fixed in the amount of 10,000 to be paid on Friday, and the reason was that it was not part of what the informal agreement was. It came up this morning, and therefore we would request.
Previously, how much did he pay?
It was 1 million rand, but it was a guarantee.
Okay.
He hasn't got that money. He simply, and the guarantee was then cancelled. It was not by way of a cash amount. Okay. And we would also ask the court to consider that amount be paid on the 11th of December. That's Friday before 1600, but that the court would order that he be released today without, notwithstanding the fact that the amount has not been paid today. May I hand to you a document that's proposed conditions, nothing more.
Yes.
Look, if I then may again summarize the format of the affidavit, it deals then with the basis for the application for leave to appeal to the Constitutional Court, and it makes then provision that bail be granted. It's subject to three things. The one is the application for leave to appeal to the Constitutional Court. The second event is that if that application is successful, the appeal to the Constitutional Court, and if unsuccessful, then the matter must come back to the trial court for a consideration of the imposition of sentence on the present conviction. Look, I may say, and when we drafted a new document, if I may just hand to you, it's not a document with correct bail conditions, but what is important is the first part of it, just to say the three steps concerning the application for leave to appeal, that it's pending the leave to appeal, pending the appeal, and pending the imposition. Sensibly, it should have been the first part of incorporated in the present bail conditions. Yes. Just the first part thereof. I submit that, say for what I've put to you, that this is really the format of the application. It deals with every section in section 64B, which is the empowering section for the court to consider bail, and it addresses every issue. We've placed that before the court. I don't think in respect of the subsections that there should be any dispute. It is dealt with, and those sections more sensibly deal with the safeguarding of exhibits and no interference with witnesses. Of course, we have passed that stage. There is no trial that must still take place, and it deals with the fact whether or not the accused is a flight risk. I can make one simple submission. This has been tested in all the other bail applications and found that he is not a flight risk. He's a well-known person. He's got a disability. He has abided by all the bail conditions all the time, and he has shown then a history that he commits himself to the structures of the criminal justice system, and we submit that he will proceed to do so, and that there is no danger or no risk for the criminal justice system, and that's dealt with. I don't know if you need any further elaboration on the affidavit, but that's a summary of that.
Regarding the house arrest, has the necessary arrangements been made with the Department of Correctional Services?
It has. In fact, Mr. Stolz is also in court, and we have arranged with him that at 2 o'clock this afternoon, permission was granted, that we would go to the offices of the department for purposes of finalizing and completing all the arrangements relevant to the monitoring.
Okay. Thank you, Mr. Roux.
Thank you,
Mr. Nell?
We just have one or two submissions to make in terms of the process. Unlike application for bail, where accused is awaiting trial, we have a convicted murderer applying for bail. So the conditions should be stricter, and that's why we've only been swayed, my Lord, not to oppose and to make other submissions by the two issues, and that is the house arrest and the electronic monitoring. And we also agreed to an amount of bail of 10,000 rand, because in the affidavit you see it's discussed that the accused does not have the means to pay a higher amount of bail. But we're comfortable that the mere fact that the accused will be under house arrest and that there will be electronic monitoring, we will ensure that the accused remain and stand his trial. As a general submission, we're not convinced that the accused has made out a good case and that his application to the Constitutional Court will be successful, but we acknowledge that he has a right to bring such an application. And
let's go back to the issue of the house arrest.
Yes, my Lord.
It was submitted earlier that I think you could leave the house between 7 and midday. Why is it necessary to change that condition?
That was a condition of his community service and by correctional services on a charge of culpable homicide and having done a part of his sentence. This is now completely different. The accused is looking at a minimum sentence of 15 years, and this is as if he's not been sentenced.
So that for him now to be in the house for the whole day, that amounts to a punishment on its own.
Not necessarily, my Lord, with the utmost respect. It is agreement between the state and the accused for not opposing. We still believe that we'll have a good case to oppose, but knowing where the accused will be for the remainder of the day, knowing that we could monitor the accused, swayed us not to oppose. And, my Lord, we still believe that this accused, being convicted of murder, looking at a sentence of 15 years, may be a flight risk.
I understand that point, but have you also considered the fact that now if he won't be allowed to leave the house within a certain period of time, don't you think that practically it may cause a problem that always he would need to phone the investigating officer to make arrangements, and that would mean that that would create more work for the investigating officer, especially having regard to how he behaved after this condition was put on him?
Well, Lord, we feel strongly about the fact that we need to monitor this accused 24 hours.
There'll be electronic monitoring should he move out of the house that can assist.
But Lord, we feel strongly that he should not leave the house at any time. And as far as being a burden on the investigating officer and Advocate Johnson, it was discussed with them. We're willing to do that. We were just swayed, and I say that with the utmost respect, not to oppose bail. Having taken into account how the accused conducted himself when he was on bail previously, how he conducted himself after he was convicted of culpable homicide. But this is different. He is now convicted of murder. There's a minimum sentence of 15 years. We will have an argument that if the Court of Appeal was correct And if the evidence that was not taken into account will be taken into account, and that's Mr. Mangena's evidence, this borders on dolus directus, and not so much on
I
the
don't
other
think
side.
there's a relevant argument to make
But
at this
the
stage.
seriousness of the conviction, I think, is relevant.
We must consider the facts that are before us.
Yeah.
The Supreme Court clearly stated that the murder charge is based on dolus eventualis.
Indeed, but in terms of sentence, and I say that with the utmost respect, in terms of sentence, the case law is clear. One will also allow degrees. On the one degree, it will be closer to negligence. Another degree of dolus eventualis will be closer to dolus directus. We say that this is serious. This is a serious offence, and that this accused is looking at 15 years. And that's why we think, and we argue, that there should be serious bail conditions. Also taking into account, my Lord, that if the accused would abscond, not having any assets or money or anything, that the only thing that he can do for now is 10,000 rand in absconding. We have in the previous bail application, and could have done it again, also argued on his links with countries like Italy and so forth, and we would have done that again, my Lord, if we did not reach an agreement. But we have reached an agreement, and we kindly... And
Well, I'm
we
not
make
bound by that agreement.
No, you're not.
Yes.
But we submit that we feel strongly about that, and would ask the court to agree.
Yes.
As a court, please. Anything that you would still want me to address you on? As far as the electronic monitoring is concerned, there's a protocol in place that we will follow. Even with electronic monitoring, my Lord, it would be easier to monitor somebody that you know will be at a specific place at a specific time. So, because now, if he's allowed to travel, to leave the house between 7 and 12 every day, we will have to monitor between 7 and 12 his movements every day. Whereas, if we know that he's leaving, and if he's leaving with permission, and we inform all people that will be doing the monitoring, that would be just so much easier. Otherwise, we'll have to focus on this particular accused every day, at least from 7 to 12, to monitor every movement.
Mr. Nell, I'm strongly considering making an order that he could leave the house, but to travel within a certain radius, a reasonable radius. What do you say to that?
My Lord, well, that would be my alternative argument. It all depends on what the radius would be. Would the court be...
As I've told you, that's what I'm considering. What do you submit would be the reasonable radius from the house?
It's very difficult. Well, at the most, not to leave the jurisdiction of the magistrate area. That is at the furthest. The closest would be, I don't know what his movements would be. I would want a radius of 10 kilometers around his house. I would agree to a radius of 10 kilometers around his house. As a court basis.
Yes, thank you. Mr. Root, do you have further submissions to make?
See there in the proposed conditions, my Lord, you would see there is a paragraph C that refers to say the accused will not leave the magisterial district of Pretoria / Tshwane. That was provided for.
In which paragraph?
It's paragraph C of the first document.
Just for the benefit of everybody and myself too, the magisterial district of Tshwane, how big is this area, the area of Tshwane? Hence I mentioned a radius which I think it would make more sense.
I think it would be about 20. I'm guessing it's quite vast. I would say about 30 kilometers at least, yeah. It should be at least about 30 kilometers. I'm guessing, but I think it's quite educated.
Okay, thank you. Yes, you may do so.
If the court considers a radius, what we'll have to keep into account that we have an airport that we would not want the kids to get close to. And so if that would fall outside that radius, that would be so much better. I've just been informed that we would be able to monitor a radius if we have all the GPS coordinates of such a radius. So if the court makes a clear indication that it's a radius of 5 kilometers, of 10 kilometers, in terms of the electronic monitoring, we would be able to monitor that. That if you would leave that particular radius, that there will be alert sounding at the control room.
Okay, can you repeat the last submission that you made?
That if the court clearly indicates that it's a radius of 5 kilometers, we will be able to do that electronically and to monitor that electronically if we have all the GPS coordinates, which we will be able to get. That way, if he would leave that radius and move beyond the radius, there will be an alarm sounded at the control room, and we would know that is a fact.
Okay. So you don't have any further submissions to make in this respect?
No, that's it.
Mr. Pistorius, can you stand up? Do you confirm that you free and voluntarily made this affidavit, which has been handed to court? Yeah. May sit. The affidavit by the accused will be labeled Exhibit A. And the court will adjourn for about 15 minutes to consider the submissions made by both counsel. Court adjourns. Before I give my ruling on this application, there are just about 4 aspects that I want to hear you on, Mr. Nell. The first one being this amount of bail, where is it to be paid?
At the registrar
Of this
of this court. As a condition of bail, if it's not paid by Friday, the bail will lapse then.
Yeah. And the second aspect is in respect of, I've been given 2 drafts. The other draft also talks about the house arrest, including accused to perform community service for the remainder of 196 hours. Is this part of the arrangement that you made?
It is. It's impossible in terms of the Correctional Services Act. The Correctional Services Act will not allow somebody to be monitored to do community service whilst out on bail and not serving a sentence.
So this will not be applicable?
No. I can address you fully on that. We investigated that. It's just not possible to do.
No. Yeah, the thing is, it's reflected on this document.
Yeah, it's on a different draft,
Okay.
yes.
And again, in the other draft, your colleague, Advocate Johnson, is also mentioned that if the accused should not leave the address without the permission of the investigating officer and Advocate Johnson. Is it necessary that he should contact Advocate Johnson? And if so, why?
If Mr. Van Aert, sorry, I forgot his name. He will never forgive me for that.
Yes.
But if Mr. Van Aert is not available, Advocate Johnson will be available. Advocate Johnson will be available at all time and is willing to do that.
Advocate Johnson is an officer of the court, and I think to put her name here, the investigating officer, if he knows that he won't be available, surely he can get another officer or refer the.
If that's the order of the court, I understand that. I do understand that. It was just to make it easier, but I do understand what the court.
It's a festive season. I don't want to put unnecessary burden on the officer of the court. Right. Okay. No, thank you very much, Mr. Nell. You may stand, accused. Mr. Pistorius appeared today in court after being served with a notice in terms of Section 319 of the Criminal Procedure Act 51 of 1977. The appearance was necessitated by the ruling of the Supreme Court, which ruling is now public knowledge, and it's not necessary for me to mention it in this judgment. Since the accused has now been convicted of a more serious crime which may attract a direct imprisonment sentence of 15 years or more if the court imposing sentence finds that there are no substantial and compelling circumstances, the court should look carefully at this application which has been brought by Mr. Pistorius. It was submitted that this bail application is brought on behalf of Mr. Pistorius as a result of the agreement between the state and the defense. The state indicated to me that it's not opposing such an application mainly because of the agreement that the parties entered into. I want to make it clear that it is the duty of this court to decide whether bail should be granted or not, and also as to what conditions should be put if bail is to be granted. The applicant handed to the court an affidavit to support his application, which affidavit sets out his personal circumstances, the history of what happened after he appeared in court for the first time until now in respect of his appearances in court. And the affidavit on page 5 thereof states that the bail is made on the basis that the application for bail is made on the basis that the bail be granted pending an application for leave to appeal to the Constitutional Court, and if leave were to be granted, pending the outcome of the appeal. And if leave to the Constitutional Court were to be unsuccessful, or if the appeal were to be unsuccessful, pending the imposition of sentence by the trial court. In the affidavit, the applicant further stated that he was instructed by his counsel that an agreement was entered into, and he consents to the restrictions that that his counsel and the state agreed upon. Since the applicant attended court, he has proved that he is not a flight risk. Initially, the applicant was charged with an offense mentioned in Schedule 6, which offense attracts a sentence of life imprisonment, and even if he was facing life imprisonment, he did comply with the bail conditions that were put by the court. I have seriously considered part of the agreement between the defense and the state that the applicant should not leave the house at all should bail be granted, and further considered that since this matter is to be postponed to April next year, as it was discussed in chambers, I am of the view that it will not be in the interest of justice that the accused or the applicant should not leave the house at all. Having considered all the submissions that were made by both counsel, I make the following order. The case is postponed to the 18th of April 2016. The applicant is released on bail of 10,000 rand and the amount of bail to be paid on or before the 11th of December 2015 before 16 hours at the office of the registrar of this court. Further conditions are the following. 1, the accused should appear at 9 o'clock at this court on the postponement date and every other date that this matter may be postponed to. 2, that the accused submit to the house arrest and may leave the house between 7 o'clock in the morning and 12 o'clock midday, and is only allowed to travel within the radius of 20 kilometers from the house, being house number 230 Lowley Street, Waterkloof, Pretoria, in the district of Gauteng. Furthermore, the applicant should not leave the house without the written permission of the investigating officer, Major Mike van Aert, who can be contacted on cell number 082 778 5604. Accused further condition is that he should not leave the magisterial district of Tshwane. 4. The accused must hand over all his passports to the investigating officer and may not apply for a passport or travel document until the conclusion of this matter. 5. The accused should submit himself to electronic monitoring to be monitored in terms of Section 62F of the Criminal Procedure Act by Mr. Stolz, the probation officer in the Department of the Correctional Services.
May I just inquire, the provision of the consent, that would be outside the hours 7 to 12?
Yes.
Yeah, just to get that said. Thank you.
Do you understand it likewise? Okay. Is that the roll for the day? Court adjourns.